Good morning, good morning, good morning, amazing law nerds. It's time. It's time. I got coffee. I got cursey words. I mean, I'm starting with hot water. Coffee's coming. Coffee's coming. But we have a lot to talk about today. As we were ending the good morning, Dr. B. As we were ending the Murdaugh trial, a massive scandal broke in the Bravo universe. And while I am not going to be talking about the entirety of the scandal, because A, I don't watch Vanderpump Rules, and B, I don't know a ton about the scandal, it has gotten very legal. There's a temporary restraining order that we're going to go over today. And it seems that there are cease and desists going out. If I get any of those, I will cover them too. We are covering the legal side of it. The chat that knows the tea can fill it in. I will give a brief overview from my understanding. There are plenty of Bravo channels that I'm sure those of you that follow my housewife stuff also follow. There are podcasts and TikToks and Instagram accounts. There's all the things if you want all the details and the day-to-day breaking news of the scandal. But in a real Bravo moment, the first thing everybody wants to know is our camera rolling. Our cameras rolling. And when this broke, cameras were rolling, and we are just a little bit away from the reunion filming, which is going to be hard to do if there is a temporary restraining order in place. So we're going to talk about the temporary restraining order. I have that. I've seen it reported on. I have not seen it covered. I'm pulling up the document, mostly to encourage others not to do so because I've redacted it. I trust my own redacting. Face Reality has all the highlights saved in her Instagram. That's perfect. There are so many great Bravo accounts. So you will be able to keep up if you want to know all of the ins and outs of the scandal. But I have the legal documents. I've redacted out the phone numbers, the email addresses, the home addresses. We don't need that to talk about it. So that's what we're going to do. Then we are going to be talking about the parody case, the Connect the Dots case. So many of you have the Connect the Dots. I'm going to put up a comment in the community tab here. So if you have done the Connect the Dots, that you can share them with the other law nerds. You can always tag me in them across social media. So Connect the Dots is second. That's what we're covering today. That's a parody case. Tomorrow, I will probably talk about what happens today in the Rust hearing, and then I will talk about the other parody case, the My Poops parody case I've been asked a lot about. We will talk about it today. So from restraining orders to parody cases, that's what we're doing today. Thank you for being here. Thank you for being a law nerd. Dr. B brought me coffee. Kind of coffee. And then I've got hot water as well. So, we are almost at a members only live stream with Dr. B. We are very close. We are very close to another Dr. B stream. And that is a Q&A Ask Us Anything stream. And we have some whiskey that we need to try. So let's get into this, shall we? I'm going to roll the intro and we're going to just get going because we have a lot to talk about. We have a lot to talk about today, but I think there's some parity to the things that we've talked about with this restraining order. Temporary restraining order is what kind of one of the things that started the Depp Heard defamation suit. It was the temporary restraining order heard around the world. So we are going to talk about this and go through all of the parts of that and then answer your questions about it as well. For those of you that found me during coverage of the Murdaugh trial, as we're shifting back into other content about other topics, I do the topics and then Q&A. Sometimes I pull in questions, but I do a Q&A at the end so that our replay crew, love you, can see all the timestamps and get to exactly what they're looking at. So let us go. Let us go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
So, the scandal. That's where we're starting with the scandal of it all. Here is Tamara. No, he's he's upstairs curled up, but our resident troublemaker Fred is upstairs. Is upstairs. I saw one more question. How do you connect the dots? I have connect the dots that I sent out on email. So if you're signed up to the Law Nerd Alert, you should have received that. If you're not signed up to the Law Nerd Alert, you need to sign up, and we will send out another round of the connect the dots later today. I will show you what they are after we get through it. So with that, the Scandival of it all, I love that it's been named the Scandival, is dealing with two individuals that are on the Vanderpump Rules show, which is a spinoff from Real Housewives with Lisa Vanderpump, with people working at a bar. I feel, and again, this is not what I watch. I apologize. I'm going to have to binge now. I feel like it's kind of Melrose Place where everybody at work kind of dates each other. So there are two individuals involved in this restraining order, but in the Scandival of it all, Tom Sandoval, the one with the mustache who has a band, his band was opening for Yachtly Crew, who I adore, the day that this all broke, which is just too funny that all the worlds spin back round. But I thought that that was an incredible just moment of coincidence. So Tom Sandoval is dating and engaged to, I think, living with, owns a house with, and has been with Ariana for like 10 years. Rachel, who's goes by Raquel on the show, but in the legal documents, her legal name is Rachel, so it's going to be confusing to get between Rachel and Raquel. Same person, was on Watch What Happens Live, Andy Cohen's show in New York, and is alleging that another cast member, Sheena Shea, punched her after that show as the scandal broke. We're going to see what's in all of this, and then we're going to go from there. So the truth of the matter is not what has been vetted here. These are, hear me, internet. These are allegations. There is a reunion pending. These are allegations. They have not been vetted by the court and won't be vetted until March. It is very easy to get a temporary restraining order. We saw that in Depp v. Heard. We do not know what has happened one way or the other. What we know is what is being alleged. These are allegations. Okay? So with all of that, these are allegations. Just keep that in mind as we're going through it. Yes? Okay. Let's go through it. We're going through the notice of the court hearing first. And as I said, I have redacted these because I redact things. So these are redacted by me. This is, I don't know why Savannah, is Savannah her middle name? I don't understand. Is that not her legal name? Did she forget? I don't understand why we've gotten to something that's being crossed out, but whatever. Is there another name? I don't know. All right. So this is from March 7th. This is the person seeking protection and all their information, seeking protection from Sheena Shea. The hearing on this is going to be March 29th at 8:30. And temporary restraining orders for personal conduct and stay away orders as requested are all granted until court hearing. That is very common. So these will be granted until the next court hearing. If no one shows up to the next court hearing, this all just goes away. But both parties have the opportunity to show up to the next court hearing and talk to the court about what happened and then decide what should happen. But the shit's already out of the horse, right? If the reunion's already filming, by the time they get to March 29th, if the goal is to keep somebody out of the reunion or have an excuse to not go to the reunion, if that is the goal, then you've got a problem. If the goal is to keep somebody away from you at work, then this is going to give time for tempers to cool. So with that, that is the court order for the next date, signed and noticed. Let's go to the application for the restraining order. That's where all the information is. That's where the photos are and all the rest of it. Again, this is redacted by me. I have seen everything under the redaction. It is personal identifying information that I don't think needs to be public, and I am not going to be the one to make it public. All the media outlets I've seen, they're like, court documents obtained by page 6, court documents obtained by me and redacted by me. So, reunion is being postponed to the 30th per the last I've read. Audrey. Well, that'll be the day after the court hearing. So this might be gone. Emma said, could Bravo get involved so that both parties can be on set for the reunion taping? It is 100-yard stay away, so I think they could probably make that work if they had somebody in a dressing room and somebody on set, and then they had, people with them moving them around. They probably could, but it depends on what these parties want to do. It just depends on what these parties want to do. So same thing. I don't understand why, if somebody can explain to me why Savannah is crossed out, I don't understand. Redacted out from addresses, but this is Rachel seeking a protective order from Sheena, and Rachel again goes by Raquel on the show, seeking a protective order from Sheena. And this is, how do you know this person? Coworkers and friends. Why are you filing in this county? The person in the harassment order lives in the county. Have you or any of the persons named in 3 been involved in another court case with the person in 2? No. So do you have other things going on? This is really common in child custody cases, things like that. Is any of that going on here? No. Description of harassment. When did it happen? March 2nd, 2023 at 1:30 a.m. Who else was there? Nobody. Nobody was present. How did the person harass you? So this is Raquel's statement of how they were harassed by Sheena. March 2nd, 2023. Pushed against brick wall, causing injury to back of head, and punched me in the face, causing injury to my left eye. Currently, mutual friends and coworkers are telling me she doesn't regret the physical attack on me and would do it again if she found that further emotional distress was caused to our mutual friend. I don't know what we mean about further emotional distress, but that's what she is saying. Did the person in 2 use or threaten to use a gun or other weapon? No. Were you harmed or injured because of the harassment? Yes. Black eye and cut/scar. Well, it's a cut. We don't know if it's a scar yet, but okay. Cut/scar to left eyebrow, blurred vision and swelling to left eye. Did the police come? No. Has the person harassed you at other times? No. Personal conduct orders. This is the most common one. Normally people will do all. I asked the court to order person 2 not to do any of the following things to me: harass, intimidate, molest, attack, strike, stalk, threaten, assault, sexually or otherwise, hit, abuse, destroy personal property of, or disturb the peace of the person. I'm surprised they didn't also check B, which is interesting to me. B is often checked, and I've filled out a lot of restraining orders in my day as a DA when people would come into court. It was like, do you also need a restraining order? Yes. Okay. I almost always check B. Contact the person either directly or indirectly in any way, including but not limited to in person, by telephone, in writing, by public or private mail, by interoffice mail, by email, by text message, by fax, or by other electronic means. State of California, hi. Can I help you update your form? Because I realize that it says other electronic means, but we really need to talk about by YouTube, by Snapchat, by Twitter. We really need to talk about what other electronic means mean. Maybe we can leave fax machine at the end, but I don't know about interoffice mail, but we really need to expand what other electronic means actually means. But I'm surprised that that is not selected. It leaves a door open. It leaves the door open to film if they wanted to film, and to third parties, their mutual friends, to talk to the others. But if the goal here is to stop someone from filming a reunion with you, why not check it? They're not allowed to contact you in any way or through a third person, which means mutual friends. Why not? So I'm surprised that that wasn't checked. Stay away orders. I asked the court to order person in number 2 to stay at least, and they had originally written 500 yards and then changed it to 100 yards. 100 yards is common. Me, my home, my job or workplace, my vehicle. Job or workplace is hard if you're going to be filming together. If the court orders person number 2 to stay away from all places listed above, will he or she be able to get to his home or school or job? Yes. I've got questions. If you are filming a show with someone and you are ordering them, so when they ask these questions, it's like, well, do you live together? Because the court needs to consider different things if everyone lives together. But if the job is filming Vanderpump Rules and the other party's job is filming Vanderpump Rules, how does ordering one to stay away from the job not keep the other to stay away from the job? I suppose the answer there is, well, you can film at different times. You don't have to film scenes together. You can both still go to work. So you don't have to work together, and you can just, separate the two. We're not worried about weapons. Does the other person own or possess any? Not that I know of. Temporary restraining order. I request that a temporary restraining order, TRO, be issued against person 2 until at least 2 words are hard, to last until the hearing, presenting the forms. Has the person been told that you're going to seek a TRO? No. Request to give less than 5 days notice of hearing. That was not requested. No fee for filing the service. There should be no fee for filing because the person in number 2 has used or threatens to use violence against me or stalked me. So they have said, look, I've been physically assaulted. This is their allegation. I've been physically assaulted, so I shouldn't have to pay to get a TRO. Possession and protection of animals, very common in domestic situations. We're not going to go through everything else. Number of pages attached to this form, 0. False. There's a bunch of pages attached to the form, including the LAPD's investigative report. So let's go over the police report, shall we? Again, redacted. This is a battery call. This was a call to LAPD. This event happened in New York in the overnight hours of March 2nd after the 2 filmed Watch What Happens Live. It is so hard to read. Victim and I think it says victim and suspect wife. No, but that's not right. I think victim and suspect were involved in verbal / I don't know what that says. But what was told to the police is that victim was punched victim, pushed victim, charged at victim. That's what it says. Charged at victim and punched victim. Left eye causing injury to victim. Victim returned to California from New York and made the report. So this is from LAPD. This is from urgent care. Date of service, March 4th. So again, this happened in the overnight hours of March 2nd. And this is March 4th. These are attached to the restraining order. And again, the reason these are so difficult to read is because this is like a tear off. This is in triplicate. So that's part of it. Okay, so this is Raquel at urgent care gave the name Raquel. In the legal pleadings gave the name Rachel. Same person, same person. Triage notes, patient was involved in a physical altercation with another person, a friend in New York in the early AM hours of Thursday morning, possible midnight hours of Wednesday. She was pushed, struck her head onto a hard concrete, and was O&M, the back end, no alcohol, no blacking out, or no ALOC. So no altered, sorry. I read that as alcohol. No altered, not altered, no blacking out, no MV, no confusion. Then she was punched and struck in the left eye, causing bruising, pain, mild vision changes, and also lingering HA from the altercation, headache. Also, the left eyebrow laceration healing well. The patient presents with chief complaint of physical altercation with a friend in New York of the head since Thursday, March 2nd. Complaints, eye pain, blurry vision, aches, pain, swelling. Patient denies the following and then goes through that. All the triage stuff that we need to do. Physical exam. Eyes, abnormality noted in the periorbital exam. Left eye swelling noted, moderate swelling located diffusely around the eye. I mean, my eyes all the time. Ethereum noted, moderate ethereum located diffusely around eye. Tenderness noted, mild tenderness, left orbital hematoma, bruise on the upper and lower lid. Eyes, abnormality noted, mild vision blurry from punch. Skin lesion to the head noted, left eyebrow, skin lesion noted. So these are the medical treatment. Assault by unarmed brawl or fight, other headache syndrome, laceration without foreign body to the eyelid. Without foreign body means really without weapon or something like that. That doesn't mean it couldn't have been a ring, a fingernail, something like that. LOS, yes, loss, LC, thank you. Loss of consciousness. Is Vanderpump Rules a reality show? Yes. Yes, it is. Yes, it is. So, they went through all the other things. They went through Pulse. This is a repeat of the other. They noted the affected area to the left eye, back of head as reported, and then photos were attached. So, again, with anything, these are allegations. These have been reprinted in TMZ and elsewhere. What I will note, these are photocopies of like photocopies. However, it doesn't look like TMZ altered them in any way. That was something I was interested to see, whether these were gained up or anything by media that has released them. The reason media has released them is because they're attached to the court documents. There is a bruise and a cut. There's a cut to the eyebrow and a bruise to the eye. So it is hard though because of the lighting, and the insides of eye sockets can be dark, but there is a bruise and a cut, and that exists. So, or at least I see that. I don't know about everybody else, but there is a bruise to the eyelid where they say it is, and on the top of the eyelid. So there is a cut in the eyebrow and a bruise to the top part of the eyelid. And then this is with makeup. I don't know when this photo was taken. So, all right. I don't know when this photo was taken. This is, there's no notation of when this photo was taken. These were printed on 3/8, but it looks like a Band-Aid over the eyebrow there. So, and then this is a post, I believe, from Sheena's Instagram that says, Sheena, always got your back, with a punch emoji, Team Ariana. So this is going to, is she admitting by using a fist emoji that she has punched someone? I don't know. But what you do on social media will be used. What you say can and will be used against you in court. So, all right. With all of that, there's the emoji. That's what's put into court. I don't know if we will see this go to court, if they will let this drop. I don't know. So some of you are saying that's a fist bump emoji. Well, here's the thing. When you go to court, whether it is a in solidarity or a fist bump emoji, if you are the party arguing that you got punched, you're going to go to court and say that's a fist emoji. She's saying that I punched her. That's what she's going to say. But it does look like, that there's no denying there is a cut to the eye. There is a cut to the eyebrow area. How that got there, we will see. And we will see if this goes to court on the 29th. This might drop. For those of you asking why no charges in the ER, this is not serious injury. And people don't always press charges. There was a police report made. It does not say whether she wanted to press charges or not. This is if anything, a misdemeanor battery in New York, but she's going to the ER in Los Angeles. There is nothing anyone in LA can do other than take a report about an incident that happened in New York. They don't have jurisdiction over it, other than to grant the restraining order. There's nothing else that can be done. If she wanted to press charges, then that would have needed to have been done or can be done later in New York. However, this is the party that is cheating with one of the members on the show. So I imagine it would probably not go over well in the press were she to then press charges against Sheena. But I don't know the inner working dynamics of this group. I don't watch this show. However, that is what it is. So with all of that, the TRO, I think, will absolutely make filming difficult. The TRO has been granted. There is a active temporary restraining order until March 29th. If these parties go to court on March 29th, this can be extended. If they don't go to court on March 29th, then it may not be extended. So let's go to the notice of hearing, and then we're going to move on to other things. Stina G said, Rachel was a fan of the show and worked her way up to this. She's trying to, we'll see. She's trying to play the victim now. We will see. Two things can be true at once, right? You get yourself into a massive scandal like this. People are going to have feelings about it, but also, you don't physically assault people if that's what happened here. So, let us, again, this whole show strikes me as Melrose Place, and I guess that's what I'm doing this weekend. Kim Jorg said her name is Raquel, not Rachel. On all of her legal filings, she's filed her name as Raquel, or as Rachel, not Raquel. So I don't know what her legal name is, but here's the thing. On the legal filings, she has filed her name as Rachel Savannah Levice. On the medical documents that are attached, she gave the name Raquel. So it seems to me that her legal name in the legally signed documents, because these are signed under penalty of perjury by Rachel. The medical documents, the police report also says Rachel, and the medical document says Raquel. So I don't know, y'all. I don't know. I think the real name, I think her legal name that she goes by is Rachel, and then she goes by Raquel. So if she pronounces it Raquel and spells it Rachel, then that's fine. I don't know. Do we pronounce Rachel like Raquel? Is that an alternate pronunciation? She posted a picture of her plane ticket before and the name was Rachel. So maybe she pronounces Rachel like Raquel. I don't know. Look, not my show. You can pronounce things a lot of different ways. I don't really care how people choose to pronounce their names. She's Raquel, but it says Rachel. I don't think you can pronounce Rachel as Raquel, but maybe you can. Maybe it's just me. So Raquel, Rachel. The thing that's interesting though is on the medical forms, it's not a pronunciation thing. Here's why. On the medical forms, it's spelled Raquel with a Q. So on the medical forms, she spelled it Raquel. I'm going by the name on the form because it's too much context switching in my head to switch back and forth. Rachel is Raquel. Same. It's Hollywood. I think it's smart to not go by your real name anyway. I'm just saying, if you want to work in social media and media, go ahead and change your name. Go ahead and change it. Just change it. Change it. Because you have a lot more privacy and a lot more options for privacy as you change your name. So I have no problem with people changing their name. So let us continue on. She uses Rachel and Raquel synonymously. Thank you, Lena G. Exactly. And I have no problem with people going by a stage name at all. I don't understand why the middle name is crossed out, and I need someone to explain it to me. For those of you in the chat, what is the relevancy? It's just because people were telling me in the chat that I was saying her name wrong, and I needed to explain. I probably shouldn't have spent 5 minutes explaining, but I did, because now we're here. I know. Quick story. Apologies. I grew up in this area. I worked in actually Marina Del Rey, where one of these parties lives. And where I worked, we had a lot of celebrities come into my workplace. It was a sporting goods store. People's kids need shoes and tennis rackets and skis and stuff. And a lot of the people who came in when they gave me their driver's license and credit cards were not the name that I knew them by on whatever TV show that they were on. Did I do that before I started on the internet? No. Should I have? Probably. Do I understand why people spell their names differently, like Nate the lawyer? Do I understand why Nate spells his name differently to be on the internet to keep some level of privacy and anonymity because the internet is going to internet? Yes. Yes, I do. I think these are probably too close to do it. So with all of that, I don't understand the middle name, but okay. Because if it's your middle name, just leave it in the filings. All right. So temporary restraining order, protected person, restrained person, details about said restrained person, coworker, friend, expiration date, March 29th at 8:30 a.m. is when this expires. Here's more, and this is what has been granted. The contact has been granted here, even though it was not requested. Oh no, I'm Emily. My name is my name. I might have to change my real name and now keep my old real name as my stage name. I don't know. I'm teasing. The shit's out of the horse on that one. Yes, Jen's woodworking. You got it. You got it. Meredith, yes, that's exactly where I used to work. All right. Granted as follows. You must not harass, intimidate, molest, attack, strike, stalk, threaten, assault. We already went through those. Also, contact the person directly or indirectly in any way. That means through third parties. So that was granted on the restraining order. And take any action to obtain the person's address or location. If this item is not checked, the court has found good cause not to make this order. So that is what was ordered. Granted as follows: stay 100 yards away from the person, the home of the person, the job or workplace of the person. Possession and protection of animals not requested. Other orders not requested. Those don't apply here. The clerk will transmit the order and its proof of service from law enforcement to be in the system. This is the signature of the judicial officer, and there we go. So that will be served in person on Sheena at some point. So those are the that is the temporary restraining order. It expires on March 29th. We will see if it is, if anyone shows up to court to seek a further restraining order, or it will just expire. Again, these are granted on signed declarations without parties having to be in court, and we will see what happens. So I'm sure Bravo will step in. You can't have cast members assaulting each other, and we've seen Bravo step in other ways with other cast members on other shows when that has happened. But here's the thing. You can't hit people. So if that's what happened here, that's going to be a problem. And also, if you don't want things to all blow up like this, sleeping with your castmates that are in long-term relationships is probably also a choice maybe to not be made. We will see what happens. I imagine that ratings are going to get a huge bump from all of this. What do you guys think? Do you think there's a ratings bump on it? Joe Jersey in the chat. I was trying to grab this. It jumped. Hold on. Let me see if I can grab it. I saw it and then it ran away. Question: if Sheena can prove this was all self-done or that she didn't do it, can Rachel get charged with filing a false police report? There are police reports here. Taking it to that level and choosing to have somebody actually pursue it as that is a bit more of a thing. But if none of this is true, and it can be proven that none of this is true, these were signed under penalty of perjury. So technically it is perjury if it is not true. So when you sign under penalty of perjury, you can be prosecuted for perjury. It's a hard thing, and most prosecution offices won't even deal with it. I tried one perjury case. There were plenty more that we could have, and they didn't. Up and Adam said, if the photos used in the filing are old, can they subpoena the metadata? Adam, it's good to see you. They can, but they would need to get court orders to get the photos to make sure they haven't been manipulated in any way. But they could use this case number to do it. That would require them to get attorneys and defend the case. So that would require that to happen because they are in the documents. The photos are not dated and you can't see them dated. However, you also have the contemporaneous medical records that indicate the cut to the eyebrow. I don't think the cut to the eyebrow is old based on the medical reports because they square. And then here, where did it go? Scandival. All right, let me pull that back up because also some of those photos look like they were taken at the location where the urgent MD care is. I don't know if that's true or not, but that's the impression it left me with. This could be anywhere. I mean, everything's got white walls, but where these were taken and when is unknown. It looks like I cannot tell if that is a date stamp on the photo or from the printout because these printouts say 3/8/23 on them in the corner. And I don't know when those printouts or when those date stamps were put there, but the contemporaneous data from the urgent care indicate a cut to the eyebrow and a black eye. So somebody else saw it as well. So yes, if these are digital photos, which I assume that they are, they can get that information down the road. They can get that information down the road and determine when the photos were taken, if the photos were manipulated in any way, and things like that. And that's part of any case where there's photographic evidence going forward, really, is making sure that the photos, when the photos were taken, where the photos were taken. And that's her apartment. All right, thank you, Miss Opinion. Miss Opinion said, I've seen it on Vanderpump Rules. Perfect. I don't watch Vanderpump Rules. I'm going to have to now. And then I'm going to be like, it's the apartment. Thank you. So the documented urgent care gives you date and gives you a dating or a kind of contemporaneous date. And urgent care noted the bruising in the upper orbital. Urgent care noted swelling. Urgent care noted the cut. And we see, I mean, swelling's always hard to see in photos. It's definitely not like Heather Gay's black eye. I mean, when we're talking about Bravo black eyes, it's not a Heather Gay black eye, but there is a bruise in the upper eyelid that you can see in the photo, or that I can see in the photo. I shouldn't say everybody sees what I see, but there is a bruise in the upper eyelid. So that's where we're at. Agreed, chat. She has fantastic eyebrows. Agreed. This is going to be a mess either way. This is going to be an absolute mess for Vanderpump Rules. Will it be a mess in the ratings gathering way? Probably. So we'll see. I see it. And your coworkers shouldn't put hands on you. You know, even if you understand why they did, your coworkers shouldn't put hands on you. With that, we just need to move on to parody. Are you ready to move on to parody? Are we ready? Heather McDonald, I know Heather McDonald. I've been on Juicy Scope. She's going off about the Scandival. I am all of the Bravo followers have way more information about this. So Sheena doesn't throw hands like Jen Shaw, allegedly. Well, we have definitely seen, I don't think Jen Shaw gave Heather Gay the black eye, but we have definitely seen people lay hands on each other on these reality shows. And I think that's a problem for the shows. I want to know what the contracts say. Can you sue Bravo if your coworker assaults you? Like, where is the boundary from what Bravo's responsible for if they create a work environment where people are going to blows after a work event? Because Watch What Happens Live is a work event. It's just, we have to get back to kindergarten rules. We were talking about this in the members only behind the scenes of the podcast for this week. We were talking about going back to kindergarten rules, like use your words, no touching, ask permission, Don't take things from other people. Like, don't take their shit out of their hands. Back to kindergarten rules. No touching. No touching. No touching. That's it. Use your words. But we all watch the Bravo shows because we love them. So we don't know. I don't think we're going to see any charges being pressed. If we did, I think that would have already happened. I think the restraining order, do you need the restraining order? Do you not need this restraining order? Is she really worried that Stassi is going to come over to her house and punch her again? I don't know if she was punched in the first place, because these are allegations. Is that the worry? What is the worry? Is the worry that they will see each other out and it will again be a mess? I don't know. But we've seen plenty of reality TV stars assault one another throughout the world, or I saw the comment about the real world in the chat, throughout the world of reality television. And at some point, I think it's going to be an issue that Bravo is going to have to deal with. And we're seeing that across other areas. There are some other legal things going on with Brandy and with Ultimate Girls Trip. A letter to Bravo was published the other day. I haven't had a chance to grab it yet, so we will get through there. Anika clarified Ariana and Tom were not married. They've been together like 10 years though, right? We're like almost at common law marriage. I have to look at the common law marriage. With that, Miss Opinion said that it says can't sue Bravo coworker or production company. I want to look at the contracts on that. So let us continue on. The bigger question, this is the bigger question, Lynn, but Bravo isn't beyond overlooking questionable stuff sometimes for ratings. And I think that becomes the bigger question of when does it stop being fun escapism and when is it just co-signing bad behavior for ratings? And where is the audience left in all of that? And at what point does the audience start to turn? So with all of that, y'all, it's time. I want to talk about MSCHF. If I say MSCHF Managed 3 times, we're going to end up with Fred here. Did I finish my water? I am trying very hard to hydrate before I caffeinate. Dear Dana said, no common law marriage in California. It kind of makes sense. Because if you're married for 10 years, you get spousal support for life. So it kind of makes sense to not common law people into that. I just don't remember. That is definitely not my area of law that I've ever paid attention to. Literally ever. Prenups a little bit because they're contracts, but not the rest of it. And I spilled on myself. Perfect. That's absolutely delightful. I love that you guys are dropping where there's common law marriage and not based on your experiences. Wendy said LVP was on, and I haven't watched it. I will, on Watch What Happens Live last night, and she was gobsmacked when she found out about the affair and seemed somewhat disgusted with both Tom and Raquel. Look, this isn't like somebody's dating for 6 months and then someone else has an affair. This is a 10-year relationship. That's a lot. I mean, that's a lot of a relationship, you know? I can understand people being surprised. All right. It's time to talk about MSCHF in the Supreme Court and parity. And for those of you that aren't familiar with this case, I'm going to give a very brief background of the case before I switch topics. I'm going to remind you, there are activities. Wait, it was happening during BravoCon? Did we know this? I clearly didn't know this. At Bravo, lots was happening during BravoCon. The thing is, Up and Adam had to tell me who people were because I didn't know who any of I knew the housewives, and that was about it. And Adam was like, this is so-and-so. I'm like, okay. I think we met Tom Sandoval at BravoCon. I'm going to tell you about the Bad Spaniels parody case. If you want the activity sheet, I took the connect the dots that are in this amicus that we're going to cover. I made them into one PDF for you. So if you want the connect the dots, you can sign up at lawnerdalert.com and it will get emailed to you later today once you sign up for lawnerdalert.com. I have a banner for that just so you can see it. And that will also keep you in the loop of all of the things I'm doing, where and when I'm streaming during the week, if I'm going to be on anybody else's things, if I'm going to be on traditional media, if I have anything dropping. I'm part of a new podcast that we're going to be talking about more soon as that's getting underway. Podcast episodes, all the things. You guys made this week's podcast episode one of my top podcast episodes ever, so thank you. And we're working on that even more. We're just going to take over. So lawnerdalert.com. And don't forget to do the likey, subscribe, YouTube things to the channel. All right, with all of that, let's get this MSCHF managed, people. Let's talk about Bad Spaniels and Jack Daniels. If you are not following the Bad Spaniels parody case, I love it. We have now the My Poops parody case that I will be talking about tomorrow. But as we're talking about the Jack Daniels Bad Spaniels case, the Supreme Court is going to hear this parody case. Let me see if there's pictures in this petitioner brief. Here's the thing. Jack Daniels, Tennessee Whiskey number 7, is suing over the Bad Spaniels dog toy. And then it ended up at the Supreme Court. We'll talk about how very, very briefly. This is a bottle of Jack Daniels. I think we need one of each of these things to put up here. But Jack Daniels, old number 7 Tennessee whiskey. Tennessee gave, it's my understanding, and again, I am not a long time Tennessean. I am a new Tennessean, but gave out their approvals to make whiskey in numbers. So they were approved number 7. So Jack Daniels number 7. This is Bad Spaniels, the old number 2 on your Tennessee carpet. Dog toy. It's a chewy dog toy joke. But is it parody or is it improper trademark infringement? Jack Daniels, this is in their brief to the Supreme Court, by the way. Jack Daniels loves dogs. They need you to know. Jack Daniels loves dogs and appreciates a good joke as much as anyone, but Jack Daniels likes its customers even more and doesn't want them to be confused or associating its fine whiskey with dog poop.
Jack Daniels does not want you associating its fine whiskey with dog poop. That is written in their Supreme Court brief. This is their brief to the Supreme Court of the United States. And they said poop. I'm here for it. This is why there's amicus briefs. I'm here for all of it. So, Jack Daniels is not thrilled.
I mean, do you associate Jack Daniels with putting it in Coke and throwing up on your carpet? I don't know. Was that just me in college? Maybe. Drink responsible, friends. We're getting back to what they said. We're just getting back to what they said in this part to give us the foundation to get to MSCHF's amicus brief. Jack Daniels loves dogs, but appreciates a good joke as much as anyone, but likes its customers more and doesn't want them confused or associating its fine whiskey with dog poop. Jack Daniels also welcomes jokes at its expense, but VIP does not just make jokes about Jack Daniels. VIP sells products mimicking Jack Daniels' iconic marks and trade dress that mislead customers, profit from Jack Daniels' hard-earned goodwill, and associate Jack Daniels whiskey with excrement. In other words, poop humor has its time and place, particularly for toddlers and young children. False. False, Jack Daniels. False. Poop humor is funny well beyond being a young child. Poop humor has its time and place, particularly for toddlers and young children, but Jack Daniels does not want its customers looking at their whiskey bottles and wondering why in the world Jack Daniels is talking about dogs defecating on Tennessee carpets. I didn't know this existed until the Supreme Court decided to take it up. So, welcome to the Streisand effect, Jack Daniels. They are not happy with the recreation of their logo, and they are very salty about it. So, Jack Daniels accordingly sought to enjoin VIP's sale of Bad Spaniels under the Lanham Act. This is regarding trademarks, claiming that the toy confused customers and infringed on the trademarks and trade dress, and diluted Jack Daniel's famous marks by associating them with dog poop and products that appeal to children. After a 4-day bench trial, the district court agreed. It was granted at the district court level. The Ninth Circuit reversed, applying the Second Circuit's decision in Rogers versus Grimaldi. The Ninth Circuit held that VIP's, quote, humorous dog toy was an expressive work, warranting heightened First Amendment protection from infringement liability. The Ninth Circuit further held that VIP's use of Jack Daniel's marks to sell its dog toy was non-commercial and thus immune from dilution liability because the toy was humorous. Under those rules, anyone using a famous mark to sell sex toys, I have a case about that, drinking games or marijuana bongs while misleading customers and destroying billions of dollars in goodwill, all in the name of just having fun. Humor does not transform the Lanham Act into a trademark free-for-all. The decision below and the Rogers decision from which it flows are egregiously wrong. That is where we're at. When can you poke fun at a trademark? When is trademark parody a transformative work? And when is humor an expressive work? When are you allowed to have a sense of humor? But on the corporate side, at some point, how do you protect your works? And this, if you are a member, you have access to my conversation regarding the Ringo case. The Ringo case is a adult toy named Ringo and the owner of a lot of Ringo trademarks, Ringo Starr, who did not want his name associated with the best-selling cock ring on adamandeve.com. But all right then. And I understand wanting to protect the way that your brand is perceived, going to the lengths and expense to get your trademark and wanting to protect your trademark. I understand all of that. So it's a difficult thing. At what point is it expressive? You know? So let us get into MSCHF. It's my favorite segue yet. It's my favorite segue yet. I'm gonna let that marinate for a second. I'm gonna let that marinate for a second. Angela A in the chat said, is this a publicity stunt? No. This is a trademark battle over what is appropriate transformative work of a trademark. This is absolutely a real big fight. This is a real big fight, and it matters. So let us get into the amicus briefs. Why do I love an amicus brief so much? Because it's somebody who says they're interested in the case because it impacts them in the work that they do. If you're not familiar with MSCHF, MSCHF is the art collective in New York that did the Satan shoes that caused the entire internet to explode. They're good at driving attention. That's what they do as a rebellious art collective. So in the Supreme Court of the United States, Jack Daniel's versus VIP Products on writ of cert to the United States Supreme Court, MSCHF Products Studio Inc., amicus brief in support of respondent VIP. This is a extensive brief. We are not going to get through all of it. We would be here forever. It's 162 pages long, but we are going to get into quite a lot of it. Interest of the amicus curiae.
Crackpots might be how the Tinker Court would describe us. Far worse. One of the other amicus called us shoe manufacturers. Ugh. How dare they call them shoe manufacturers? They don't manufacture shoes. Meanwhile, members of the art world named us the future. We call ourselves MSCHF. Pronounced mischief.
Footnote 1. No counsel for a party authored this brief in whole or in part, and no counsel or party made a monetary contribution intended to fund the preparation and submission of this brief. No person or entity other than amici, their members, and their counsel made monetary contribution to the preparation and submission of this brief. Just so we know. We are a collective who critiques and comments on American culture. The renowned I'm going to pronounce this wrong, Periton Art Gallery describes our work as elaborate interventions that expose and leverage the absurdity of our culture, political, and monetary systems. They do that. We start conversations about culture by participating in culture. So we agree with this court that the freedom of expression is not limited to areas that the benevolent government provides as a safe haven for people like us. Oh, I read that wrong, but it was a great sentence, so I'm going to read it again. So we agree with this court that the freedom of expression is not limited to areas that a benevolent government provides as a safe haven for people like us. Right. Our cultural commentary varies. We brought attention to the burden of medical debt by soliciting unpaid medical bills, then painting the bills on to a canvas and selling the art to pay off the participants' medical debt. By cutting up Hermes Birkin bags and selling them as sandals, they made Birkins. By cutting up Hermes Birkin bags and selling them as sandals, we commented on the obsession with high fashion and how society assigns value based on a good's placement in the supply chain. 76,000 Birkenstocks made from actual Birkin bags. They were Birkin. Warning, neither Hermes or Birkenstock has approved this product. Birkins. At Art Basel this past December, I talked about this on Twitter. At Art Basel this December, we challenged society. I didn't know this was MSCHF that did this. I hated this idea, but I liked it, but I hated it. I thought that this was a massive security issue, but I was fascinated by it all the same. We'll get into the Birkin, Meta Birkin fight at some point, maybe. At Art Basel this December, we challenged society and the art world's desire to flaunt wealth with ATM leaderboard. The piece allowed participants to put their bank card into an automatic teller machine that displayed how their account balance compared to the riches of the other participants on the leaderboard. People put their ATM cards into the ATM machine. It took a picture of you and then displayed your bank balance. Yeah. I didn't know if it was skimming bank accounts though, because you had to put your PIN number in. And so, yeah, Lexi in the chat is like, so they just have everyone's bank information. Right. It freaked me out. Hold on. Sidebar. There's a video. I have a video. Did you guys not see this? You might not have seen this. I have a video about it. I want to, hold on. ATM. Let me see if I can find it. Quickly. There's a video. Let's see. Oh, this one's up on YouTube. Here we go. Let's just grab this one from YouTube instead of from Twitter. There we go. This is from the Miami Herald. Okay, perfect. All right. Shall we? Yes, let's. Let me open this up on YouTube real quick.
An ATM.
Yep. So I remember the video I saw, the leader had millions in their bank account, and I had questions.
We made an ATM that has a leaderboard on it. Totally functional ATM. Take money out, check your balance.
Okay, wait. We're going back. 2.98 million. High score. 2.98 million is the high score with a photo.
Functional ATM. Take money out, check your balance, and just.
I didn't realize this was MSCHF. It all makes so much more sense now. Oh no, they're not random numbers. This is a bank account. Yeah, it's wild. That's what I said. T6 Beats is like, how to get robbed. Right, here's your bank account balance and your photo on the internet forever. It's just.
Ranks everybody's balance.
The ATM, kind of like the super literal act of just displaying how much money you have on your photo for everyone to see, is
yes.
Like the least subtle possible version of the kind of conspicuous wealth flaunting that is, that's sort of the content.
I love that this is an interview with the MSCHF artist. This is so much better than just seeing the video about it.
The constant subtext of a fair like Basel, of a city like Miami, just instead of doing it with a car or a Rolex or the
Or the
buying
art
a
that's
piece of
just
art.
around,
Right,
yeah.
right. This is the sort of like the blunt force implementation of that.
Blunt force implementation of flaunting wealth. And the thing is that they were so confident people would participate because the artists at Mischief clearly understand humans and know that the humans that are at Art Basel are going to flaunt their wealth one way or the other.
Some people are very hesitant and some people
Oh,
are
I would
absolutely
never.
not. There's been a lot of, like weird peer pressuring of friend groups to push someone to try it.
Oh, I would never.
But I actually think doing it is very brave and kind of like radically transparent to some extent. It's a really brave act, I think, to do it, especially when there's a crowd and a bunch of
I don't know if it's bravery.
people looking and knowing that your face is going to be on this leaderboard for as long as this object exists.
And the other thing is, people are hesitant because they feel like they don't have enough money in the bank account. They're not going to hit the top 10. But as we're watching it, I mean, we're kind of thinking like,
I mean, honestly,
in some
would
ways,
not
like,
want to be in the top 10.
right.
Yeah.
The higher you are up on this list, the more the piece is making fun of you. So,
Yeah.
So that I didn't realize that was them. I'm a big no on that. You've got to put your ATM into, you've got to put your PIN code into it. Skimming is a huge issue when it comes to ATM machines. You don't know the security, but that's my lawyer brain of like, wow, they could just have literally, what if the art, this is what I had joked about at the time on Twitter. Like, what if the art exhibit is that now that they have your ATM, PIN code and your bank number and your ATM card number, what if the true performance art is they just drain your bank account and all the numbers at the end go to zero and they've drained everyone's bank accounts out and it ends up being like an Ocean 11's heist. I'm like, is that what the purpose of the art is? And then they're like, oh, it's just art. I didn't know this was them. So I'm here for it. All right. Our cease and desist Grand Prix project spotlighted how multinational corporations abuse the Lanham Act through cease and desist threats to prevent speech. Likewise, TAP 3 highlighted the constraints that litigious corporate property holders impose on creativity. We invoked the profile of a popular sneaker, wrapped it in Mischief branded tape to dispel confusion and symbolically demonstrate how the likelihood of confusion test restrains expression and creativity. This is going to trademarking exactly. The Perotin Art Gallery hosted our debut solo art exhibition in late 2022, footnote 2. No More Tears, I'm loving it. There's a link to that. At the show, we featured a piece called Wavy Shoes, which responded to a preliminary injunction issued against us when we used a wrapped shoe as a medium for our critique of both sneaker culture and the shoe manufacturer Vans. While fully respecting the injunction, Wavy Shoes extends our critique of sneaker culture by placing this piece at an art show. We also demonstrated how corporations use the Lanham Act to confine speech to approved spaces such as white-walled galleries. By drawing on existing symbols and ideas, sneakers critique society and communicate their own ideas. We appreciate how the Lanham Act protects the source identification for goods and services, but iconic symbols represent culture and are necessary shorthand for commentating on society. So let's begin. Mischief. Here, the footnote is on their case against Vans. We're going to pull this one too. The matter is currently before the Second Circuit. And as Judge Dennis Jacobs accurately stated in oral argument, the piece critiqued the objectification of the wholly consumer product of sneakers to be a collectible, and that that is absurd and a sign of cultural crisis. So then they've listed the oral argument, which we could probably hear. Our appeal is currently held in abeyance. Mischief did the Satan shoes. I'm surprised they didn't bring it up. But that's how I came across Mischief, was the Satan shoes with Nike. And Nike sued to get them to stop selling the Satan sneakers because they were so annoyed that everybody on Twitter was flaming Nike for, Satan sneakers. Nike was big mad because their iconic swoop was incorporated in the sneaker that was the shoe that they took and added symbols and different artwork too. So Nike big mad about it. But that lawsuit went away pretty quickly. The shoes were all sold. The lawsuit stopped, and that was the end. I loved it though. All right. Call for entry. Show title, Where to Draw the Line. Dear Chief Justice, Associate Justices, and law clerks of the Supreme Court, we invite you to submit artworks to Where to Draw the Line, a group exhibition planned to open in the fall of 2023, curated by MSCHF. MSCHF, the law nerds want an invitation. Submission requirements. The show will be composed of 45 works on paper, each taking the form of a connect the dots drawing, a classic childhood puzzle drawing format. Enclosed in this brief are 45 pages. I grabbed those out of the brief and I will email them to you for personal use. Enclosed in this brief are 45 pages, each specifically addressed to one of the people reading this brief. Emily D. Baker is also reading this brief. Hello, MSCHF. Each page has on its front face a connect the dots drawing, waiting for an artist's hand to make them into completed artworks. On the reversed is a pre-addressed, prepaid mailing label allowing the completed drawing to be returned to MSCHF for exhibition at no cost to the artist. Find and complete in your own hand the prompt addressed to you. They gave the Supreme Court an art project. They gave the Supreme Court an art project. The way that I fucking love this so much to make the point. I love it so much. I actually love it so much. Find and complete your own. Remove the completed drawing. Don't forget to sign your work from this brief and fold the drawing into thirds with the mailing label facing outwards. Close with a bit of tape and send to MSCHF. Curational statement. These connect the dot works follow in an established tradition of uncreative art that stretches from, I'm not going to pronounce any of these things properly. I didn't study art. My mother would be appalled. To Warhol's paint the number works. Such artworks historically have been deliberate recreations or deliberate reactions against or critiques of the art world, conventions around craft, ego, and formalism. In this combination of action, artist, and dissension that determines exactly what those artworks are, not merely the nature of the manual execution. Each of you, by virtue of completing one of these drawings, is the executor of the artwork that makes use of cultural iconography. Each of you, by virtue of your position, may decide the fate of artistic expression, ability to freely choose its subject matter. Each of these drawings will be displayed as part of a gallery show. Will they be rendered illegal prior to that exhibition? It's just so fucking smart. If the Supreme Court rules in favor of Jack Daniels, all the artworks here might also be rendered illegal or rendered infringing. Terms: the 45 artworks solicited by this call for entry shall be provided to MSCHF on a consignment basis. All rights and ownership are retained by the artist. The artist grants permission for the sale of the artwork at the price listed in the call. Taxes and fees, are the responsibility of the purchasers. Unsold works will be returned to the artist prior to the closing of the show. For those of you in the chat asking, how do you get the connect the dots? lawnerdalert.com. So these are the artworks that I pulled and sent to all of you via email. Heather Gobble, if you want to email it to me, my public email, the @Semaphore is the perfect one to send it to. I'm also going to put up a community post so we can post the pictures of them in the community. So this is to John Roberts, Arm and Hammer and Sickle 2023, pen on paper, connect the dots. Arm and Hammer and Sickle, because these are now getting into iconic trademarked brands. And yeah, I want to see the connect the dots. Yes, the connect the dots are very small. Yes, it is a problem. Yes, this is a filed Supreme Court brief, and I find them hard to see, though I think you can parse them. This probably spells arm and hammer and sickle around the outside. And then this is how to mail it back. We're going to go through each one of these. And if you want them, again, lawnerdalert.com. Samir Doshi, Bathroom Break 2023. I don't know what that one looks like. The BYU Cougar fucking kills me. Go Cougars 2023. See, because you can tell by the fingernails It's gonna be a play on a cougar, but it's the BYU cougar. Gosh, I love it so much. This is Rush Delivery 2023. I imagine that's at FedEx. You can tell by the arrow and the car crash. So FedEx, let's see. Jack in the Dropbox 2023. I love seeing how many of you did these. It's so great. Let's see. This is No Orange addressed to Clarence Thomas. I imagine that's a like mind blown kind of an emoji. Let's see. The Chicago Bulls sports drink. I wonder what it says underneath. I don't know. But there are the dots. I'm going to try to do these as well. But that is clearly the logo of the Chicago Bulls. I don't know what it says down below. This is last place. Some kind of a sneaker. This is Oscar the Couch. I don't know. This might be my favorite. The BDS M&M. It says Red Bull. Thank you. It says Red Bull. That makes perfect sense. Of course it says Red Bull. Of course it does. Here's the thing. Syracuse Orangemen is the BYU logo. I wonder who was the Syracuse Orangemen addressed to? Was it Clarence Thomas? I wonder if Clarence Thomas went to Syracuse. I don't know these things. I wonder if. Oh, the S makes sense. All right. So Chicago Red Bull. See, it's a mashup. The BDS M&M, I think, happened before the M&M's scandal, but I'm here for it. I think it's hilarious. They assigned Shapiro to the BDS M&M. Yep, they did. They sure did. I just. Okay. This is to Samuel Alito, Back in Black. I think it says Alito instead of AC/DC. I'm imagining that's what it says. Because I can see the T and the O on the outside there. So I imagine it says Alito in the AC/DC logo. Taco Hell. With the iconic Taco Bell bell. God, that's gonna. No, I'm too suggestible. I'm like, God, tacos do sound good. What are you doing in my swamp? What are you doing in my swamp? With is a mashup between Mickey Mouse and Shrek. Yep. All right, Kellogg's. This is part of an unbalanced breakfast with the Fruit Loop toucan. I don't know what it says in front of Kellogg's. I don't know if it's a K or not. But there we go, the toucan. This is No One Out Pizzas the Butt. So I imagine there is a Pizza Hut butt. I'm here for it. Let's see. This one is Yes We Can of Soda Mayor. No idea what the Yes We Can Soda Mayor is going to be, but I imagine it is, I wonder if it's Coca-Cola inspired. I know some of you have done these. This is why I'm putting up a community post for them. Harry Potter and the Prisoner of Corporate America is sent to Paulina Arnold. So there's that. We have the Botticelli instead of a Botticelli in the shell. I don't know what corporate logo it'll have, but I imagine it. Would it be Shell Gas? It seems like it would be. The New Yorker with Mr. Peanut. I love New Dork. Oh no, that is the New Yorker. And that's going to say the New Dorker. I don't know what this says below it, but here we go. Section 230. 2023 with the Monopoly Man. Wow. Well, that's a societal commentary, isn't it? I'm here for all of this. I'm here for all of it. I'm here for all of it. I guess that's how they're feeling about Section 230 in the internet. With the guillotine and the Monopoly Man. I mean, is there a better iconography for like corporate greed than the Monopoly Man? I kind of like it. I kind of like it. Jennifer Smith in the chat said, I'm confused. What are these? These are a Supreme Court art project. What is Section 230? Oh, y'all. Section 230, we're going to be talking about again. Oh, yeah, it's definitely a guillotine. We're going to be talking about Section 230 again soon in Google versus Gonzalez versus Google. Section 230 is the section that protects the internet providers, Twitter, YouTube, and others from being sued. So it allows them, I have other content covering Section 230, but it is the section that allows or originally allowed, you know, a listserv to be hosted without the host of the listserv being sued for what was said on it. So you can't sue Twitter for the things people say on Twitter. There are two very large cases about Section 230 before the Supreme Court right now. So that's a brief summary. It allows social media platforms to not be sued for the behavior they take or don't take. This one might be one of my favorites. The Supreme Court of the United States, this is going to Justice Kagan, but using the Supreme logo. I'm here for it. Jessica said, this is a Supreme Court art project. Ever thought you would say the words, Emily? No, and I'm living for it. No, and I'm living for it. If you email us at Law Nerd Alert, I have taken all of the connect the dots and put them together into a PDF for y'all if you want them for fun, for personal use. All right. This is America Runs on Drunken. And I think it says Drunken Rodents, I would imagine, based on the little logo. I kind of love this take on it. It's hilarious. So, Emily, you need to send these to Hogue. I will absolutely send these to Hogue if Hogue wants them. Bad Apple, which looks like the Hungry Caterpillar worm to me. Let's see. This is Stolen Valor. I don't know what this one will say, but we will see as it gets done. Sharpie 2023. I imagine that is going to be what, on the blade of a knife? Yes. Looks like it. This is Bass Pro Shops. Wait, that says Bass Pro Shops. That says Bass Pro Shops. With the speaker. These are hilarious. Oh dear. Spearfishing 2023. Is it chicken though? But is it chicken though? It's a chicken. Is it a chicken or is it tuna? But is it chicken? I don't know. This one is titled Goes Down Smooth. I don't know which oil logo that's going to be. I can't quite tell, but in the Pepsi can. And then Hello Kitty is not a cat. Abercrombie and Stitch. And you can see the Disney character Stitch there with the iconic Abercrombie font. And I imagine the Stitch logo down below. I'm a sick Mario. I'm a Mario. I don't know. This is Speak Popperly 2023. Duplo with the Duplo owl with legs. Duplo being a type of Lego. And now a word from our sponsors. There's a lot of these. How to hold a toddler. I don't know if I want to know. Disney needs ice. What else? McMass. Oh gosh. Oh, is it the Duolingo owl, not the Duplo owl? Thank you. It is the Duolingo owl. My brain conflated the two. Thank you. Because my brain conflated the two. Dua Lipa X Duolingo. Thank you. You guys are, see, this is why we need the chat. This is why I live stream. Y'all are smarter than me. Um, the Church of McDonald's for Amy Coney Barrett is just chicken tuna is Jessica Simpson, but it's a chicken is also this last trial. So I like that they actually we broke the webpage. Did we break the webpage again? We might have. Give it a minute, it will work. If we broke the website, I will go check on it afterwards. Oh no. Which it looks like the Hawaiian Punch mascot is leaking punch. Ralph Lauren is winner winner chicken dinner. This one actually is a chicken. This one actually is a chicken. There's a 503 traffic error. Okay. We will fix the 503 traffic error. Do not fear. The Kool-Aid Man. Yeah, oh, what did I say? I'm going to just stop saying them wrong. Revenge of the Chickens. Yes, the Kool-Aid Man. Did I say, I said Hawaiian Punch, didn't I? I did. Not the Kool-Aid Man. Anyway, winner, winner, chicken dinner. Cowmen instead of cowboys. Oh, I can see how that's going to go. Yep. Cowmen. Dumb Express. I wonder what they changed the face to. It looks like there might be drool involved for the American Express logo. Oh, not the Jack Daniels. Not the Jack Daniels. Whiskey the Pooh. No. Why didn't they make it honey flavored? Why isn't it Jack Honey? Mischief. I realize it's easier. But it's a big tongue, not drool. Well, that's good to know. Oh, my comments won't pull up. There we go. I think they needed the honey whiskey, but we get the point. DC Public Defender's Office. Backwards, which is very difficult to read. But the DC Public Defender's Office. This is Return to Tradition. Dead bird. I like that you can see the splat on the glass. Is it another chicken? I don't know. I know the backwards is the point. It's just hard for my dyslexic brain to read. Heads up. Now with cocaine. There we go. Let's see. All right, back to the argument. After we have seen so many riffs on trademarks in the Connect the Dots art. Look, I'm here for it. You guys said I think it's the Twitter bird. Oh, that probably makes sense that it's the Twitter bird. That probably does make sense that it's the Twitter bird. Again, I have not done the Connect the Dots yet, but that makes sense. So in this, the Twitter bird makes a lot of sense. This is probably Coca-Cola, right? So all of these Connect the Dots are to make the point. Lacey said they don't want their whiskey associated with any poo, and there is poo all over that. Yes. I think it's clever in a lot of different ways. Wait, where did Winnie the Pooh and Jack Daniels go? How far back were Winnie the Pooh and Jack Daniels? Yeah. Jack Daniels, we just read the excerpt that Jack Daniels does not want to be the Alito one says NATO. Oh, Dark Freeze, that makes sense. Dark Fire Zero said the Alito one says NATO. Look, man, the Art Collective is coming for the Supreme Court and for this case, but taking on the different takes on traditional trademarks, and these are showing all the different traditional trademarks. So again, for those of you that want I have pulled these out and put them together. And with pulling them out and putting them together, they are available on lawnerdalert.com. if you sign up for our email list. I will send it to you. Summary of argument. Freedom of expression does not exist if it quote, could be exercised only in an area that a benevolent government has provided as a safe haven for crackpots. We do not confine the permissible exercise of the First Amendment rights to a telephone booth or the four corners of a pamphlet. This is Tinker versus Des Moines. Freedom of expression and what is and is not speech are huge arguments. Law and Order Alert is down, y'all. A lot of you went to go sign up. It'll be back. We keep having that problem. We have the direct link as well, which might help on that, but that happened the last time we sent y'all to sign up. We have been working with our web provider and we've said, look, we need extra bandwidth. So we are working on it. Let me see. All right, let's keep going. We communicate using symbols found around us. By taking what you found and adding your own expression, you just participated in one of the most cherished traditions, freedom of speech. This is a tradition of evaluating what came before and interjecting your own thoughts into the conversation. By its nature, freedom of speech is appropriative because it draws on existing cultural resources. In a democratic culture, people are free to appropriate elements of culture that lay to hand, criticize them, build upon them, and create something new. This is coming from Democratic Culture, a theory of freedom of expression in information society. Under longstanding First Amendment precedent, you also control how you share your expression. You could now sell your expression on tote bags at the Supreme Court gift shop. You could assemble the 12 best pieces and sell them as a calendar, or you could take all 45 artworks, add a few more, and sell them on playing cards. Of course, you may also offer your work to the gallery. The choice is yours. This exchange of expression is a two-way street. Trademark holders routinely take from art and culture and add their message to imbue their marks with meaning. Meanwhile, artistic and political speech use the cultural renaissance of trademarks for their own expression. Jack Daniels and its amici seek to suppress this free flow of ideas. Their proposal suggests speech should be limited to clear speech or to the safe haven of pre-approved mediums enforced through content-based regulations. This court should reject their effort. Instead of contradicting centuries of precedent, we ask this court to honor established First Amendment principles. The appropriative test is to ask what is sold. If it is speech, then the use of a trademark is non-commercial and permissible. Here, VIP sells a joke. The parody comments on how dog owners like to humanize their animals and the role of alcohol branding in society. Like your own artwork, this expression is clearly protected speech under the First Amendment. So the positioning of MSCHF and its lawyers is that the parody toy, the riff on the Jack Daniels alcohol bottle, is a broader comment on society saying people like to humanize their dogs. People were taking a stab at alcohol culture and the way that alcohol culture is prevalent. And that is a joke. And if you don't get the joke, that's too bad. We have multiple parody cases coming up before the Supreme Court, including the parody Facebook group poking fun at the police. I don't remember which police agency it was. So there are multiple parody and First Amendment cases coming up. First Amendment cases can be difficult sometimes to talk about because a lot of the times they come up in the context of speech that a lot of people find to be unpopular or challenging or sometimes even abhorrent. This is an easier context to talk on the internet, at least, about free speech, protection of speech, ideas, and jokes, because we're talking about trademark parody. And so it's a really interesting vehicle to discuss the First Amendment brief and to discuss the First Amendment and what is being protected, because you're not really dealing with abhorrent speech. I don't think most of you in the chat would find the Jack Daniels trademark abhorrent. Law Nerds, I love that you crashed our website again. We'll get it up for you today. Don't worry. Don't worry. We will fix it. You might just have to try again in a minute. Which is why I wanted to cover this. More, because first of all, we have the artwork that pokes fun at the whole thing. We have the cleverness of the argument and the conversation, but we also have a very valid conversation for now. When do we talk about free speech? Often it's with abhorrent speech, as I just said. So being able to talk about free speech and being able to talk about the protections of free speech, even when it's speech you don't like, is interesting in the context of trademark for me, because at some point, how do companies protect their reputation? And are we back with the internet in the wild west of anything goes until we figure it out? The arguments. The free exchange of expression is essential to a free society. I have a lot of thoughts on this one that we're not going to get into today because we don't have time about whether social media is allowing for free exchange of expression. And I would just posit that there are larger questions about whether social media actually allows for free exchange of expression, even though I find a lot of what happens on social media to personally be abhorrent, and I don't personally like it. Whether or not there are free exchanges of speech happening on social media is a big thing. So, and that's not just speech that we like. This is a battleground. This is a battleground for free speech, and there's it's a more nuanced conversation. I just want to talk about it in this context today, but it is a concern. It is a more nuanced conversation, and it is a balance between what is free speech, what is protected speech, what platforms have to do, and what, like in our space, we have rules in our chat for no name calling and what have you. I'm, as a creator, I can enforce the rules I want to create and enforce the rules I want to enforce in our space as a creator. Where are companies beholden to enforce the rules they want to enforce? Where is that overstepping on free speech? And then where is the government informing those rules? When you have government entities reaching out to social media platforms saying, we need to suppress these stories, that is a much different thing than, YouTube saying our advertisers don't like these particular words. And where is the boundaries of that? And these are conversations we have to keep having. And we have to talk about when the government is impeding on speech and where those areas of expression still lie. Advertisements appropriate art. By using meaningful iconography, companies imbue meaning into their logos. Once companies add meaning to their logos, the logos become useful tools for commentary and critique. This is, Campbell's soup art. Is it art? Is it not? And this is the same session of the Supreme Court that we're going to be looking at transformative works in the context of the photo of Prince being transformed into a painting. So the Supreme Court is dealing with the parody Facebook account, with what's transformative work under copyright with regard to the Prince photograph and the painting, and dealing with Jack Daniels' Bad Spaniels. So we have three different contexts that we are now dealing with: speech, expression, trademark, copyright, what is allowed, what is not allowed, and where is it? And I appreciate that MSCHF started out with, our speech should not only be protected by a benevolent government. Do any of it? I'm going to just stop. Our Constitution grants us rights that are our rights, are inalienable rights. So relying on the government to allow us permission to use our rights becomes an entirely different thing. So I appreciate the way that they have attacked this case. I think it's very clever. And I understand the arguments on both sides of it because I understand copyright holders and trademark holders saying, what the fuck can we do? We have the right to protect our company and our brand reputation that we've built. There's value in brand reputation. And now we've got like just corporate culture and consumerism and capitalism and freedom of expression all bumping up against each other in what I find, and I hope you find to be a very interesting Supreme Court case. So hopefully you find it interesting and I am not just ranting to myself. It seems like there are still like almost 11,000 of you here. So I know that I'm not just ranting by myself. I think it's a very interesting conversation. Justina said, I'm sad the website's down. Me too. I thought we had fixed it during the trial. We had been promised that they were going to load balance our website. So my level of frustration, I can't even express because otherwise I will never finish talking about this today. So, I saw Tracy Sires in the chat say lots of people have tattoos of characters. Tattoos aren't necessarily safe. There is a tattoo case. There's a couple tattoo cases, but tattoos aren't necessarily safe depending on what they're recreating. Tattoos have not always been ruled to be transformative works of art. Most people don't go after them, but tattoos aren't necessarily safe. The two cowboys on the page look similar for good reason. Which cowboy? These two cowboys. Successful trademarks appropriate cultural iconography. Both cowboys project individualism and a brand of confident masculinity. They differ, however, in an important way. The first cowboy is actor Montgomery Clift in the 1948 film Red River, selling an artistic vision of the Old West. The second cowboy is one of the original Marlboro Men, featured in 1955. In a 1955 advertisement, he sells cigarettes. So they're saying vibes? Vibes? Companies create iconic trademarks by borrowing from culture and adding their sales pitch. For several decades, Marlboro cigarettes sold poorly because men were not attracted to the product due to its packaging and feminine aura, and relatively few women smoked. John G. Breyer, Cowboys, Europe and Smoke, Marlboro in the Saddle. I can't pronounce that well at all. So Lee Burnett introduced the Marlboro Man. Lee Burnett wanted to communicate masculine confidence, and its research demonstrated that the American cowboy was the most effective messenger. New from Philip Morris. By the mid-20th century, the American cowboy symbolized rugged individualism and manliness. We're everywhere. We're everywhere. We're just everywhere today. Corey, I agree. But the image of a stock cowboy is as much a fiction in America as Uncle Sam, the cowboy America's contribution to the world's mythology. In their heyday, the reputation of cowboys was mixed at best. Contemporaries describe cowboys as people living remotely from the restraints of a moral life. Oh. And who loiter sometimes for months and share the boughten dalliances of fallen women. Hey, I feel attacked. Leave the fallen women alone. Sorry, it's from 1952. American art so effectively transformed the image of the American cowboy that the Marlboro Man advertising campaign worked for Marlboro everywhere except Argentina. Huh. In Argentina, American art never transformed the gaucho into a mythical icon. Instead, the gaucho continued to embody, quote, poor, dirty, statueless drifters at the bottom of the work ladder. Without art providing a ready-made symbol for Marlboro to appropriate, none of Marlboro's massive marketing budget or goodwill could spur sales. That's a very interesting argument. The cultural iconography around the American cowboy is why the company then chose to use that as their symbol. Huh. Borrowing from art to develop trademarks is common because advertisements must leverage meaningful symbols and icons to acquire value. They're talking about the masterpiece Untitled, I Shop Therefore I Am, which uses a red box with white text in Futura bold oblique font to express her criticism of consumer culture. I shop, therefore I am. In 1994, Supreme's CEO wanted a symbol for his fast fashion store, so he gave their designer a book of Kruger's work to develop a logo. The Supreme logo and Barbara Kruger, a history. The result, I'm going to go down such a rabbit hole on this. Can you feel the rabbit hole? Can you feel the rabbit hole? Can you feel the rabbit? I feel the rabbit hole coming. I love how clever this amicus is. This is why I enjoy Supreme Court cases, because you learn so much. I don't always enjoy every Supreme Court case, but I love this is the part of law school I really enjoyed, was the like, where do you end run this? And when you take this thought and run it out to the end, like, where do we end up with trademarks and property and protection and ownership? And what does that even mean in a digital world? I feel it. I love it. I'm here for it. Supreme CEO wanted a symbol for his fast fashion store. He gave their designer a book of Kruger's work. The result inverts the artist's message while borrowing her aesthetic to lend an air of pop art to Supreme's fashion offerings and suggest it is a rebellious brand, quote, outside fashion. The appropriation worked, and now Supreme is a worldwide clothing and skateboarding company. As we know, the plight of pop art or cowboys is not unique. Starbucks borrowed its name from the first mate, Mr. Starbuck of the novel Moby Dick. And the mermaid on the cup, it's a siren. And the mermaid on the coffee cup is Melusine, a mythical siren of medieval Europe. Right, it's a siren. Mermaid, siren, princess, how the Starbucks logo evolved. There's articles on all of these. The amount of things I need to read. As Starbucks admits on its website, its use of this medieval symbol evokes the seafaring tradition of the early coffee traders. With its icon status, the logo carries considerable expressive value. For instance, it can be used to critique Starbucks' own labor practices, as seen here, e.g. Cultural expressions and iconography also bestow meaning and expression on trademarks, and companies appropriate these symbols in the name of developing goodwill. For example, Quaker Oats adopted a man in traditional 17th century Quaker garb because the association with Quakers symbolizes good quality and honest value. Coca-Cola's advertising appropriates Santa Claus. It does? What? Coca-Cola, this is a better look. I never took marketing. I focused my undergrad studies on going to law school. I am fascinated by all of this. Thank you for taking the dive with me. I just am loving it. Coca-Cola's advertising appropriates Santa Claus and claims they established the modern version of the Jolly Elf. Quote, they did not. David Mickelson did Coca-Cola invent the modern image of Santa from Snopes in the Supreme Court brief. Anheuser-Busch borrows the American flag and other patriotic iconography to suggest that your 4th of July picnic is incomplete without a Budweiser beer. Similarly, Nabisco appropriates patriotic iconography, suggesting eating Oreo cookies supports your country and Team USA at the Olympics. Oreos are delicious, though. As recently... Oh, God, the boots! How are the boots here? The fucking boots are everywhere. We recently experienced this phenomenon ourselves. As a fun comment on cartoons and our increasingly abstract world, we released Big Red Boots. See Jacob Gallagher, MSCHF Big Red Boots. Corporations jumped at the opportunity to use our art to suggest they and their products are similarly fun. Baybel Cheese, been there, done that. Someone else can have the other boot. I only need one. Slim Jims. Pepsi. Blue is really more of our color with the boots. Wait, there's Peeps flavored Pepsi? Thanks, I'll take it, said Axe. We got you on the matching socks. KFC. Oh my God. Even the most notorious trademark registrant of 2022 joined in the fun. Ohio State Facebook. Okay. All advertising leverages iconic imagery and symbols to send a message to potential customers. The setting, the music, the clothing, the people in the advertisement all borrow from our cultural cultural archetypes to express something about the company or product. That expression becomes part of the meaning of the trademark, and that meaning is valuable for expression unrelated to the sale of goods. both political and artistic speech, appropriate trademarks. NASCAR's rise collateral with the growth of incomes for the working class, white men in the Southeast, and NASCAR adopt symbols of Southern culture into their race car names and customs to cement the relationship with the demographic. And then they talk about NASCAR. The phrase "let's go branding" quickly became, I didn't know we were going to get so political so fast. Emily, start pre-reading your stuff. All right, y'all, just hang through the argument. The phrase "let's go branding" quickly became a euphemism for expressing dissatisfaction with President Biden. To express this sentiment and underscore their own connection to NASCAR dads, the Republican Party sells speech in the form of a portion of the NASCAR logo with the phrase "let's go Brandon." Interesting argument to the Supreme Court. Public health departments have also used corporate trademarks such as the I like that they're bringing in the way that politicians do the same thing. I really do. I really do appreciate the way that they're bringing in, look, it's not just artists, it's not just advertisers, it's not just companies, it's political parties, it's public health organizations. I really appreciate how broadly they are pointing out all of the different uses of trademark. Public health departments have also used corporate trademarks such as the Marlboro brand and then added their own commentary about health and safety. I missed my lung, Bob. Political campaigns incorporate corporate trade dress too. On January 1st, 2000, a forgettable insurance company named American Family Life Assurance Company ran a commercial with a duck. The Aflac duck taught millions of Americans about insurance, and Aflac sales doubled. 16 years later, American Family Life Assurance Company. That is Aflac. Okay, fair enough. How I did it, Aflac's CEO explains how he fell for the duck. As long as it's not Howard the Duck. 16 years later, a young politician in Hamilton County, Ohio, named I am not going to be able to pronounce Affabbed Peruvial, also needed to overcome a different name. He appropriated the Aflac duck and placed a modified version of the duck in his commercials to help voters remember him. Watch AtFab. AfTab, I think. And I don't mean to pronounce it wrong. Thank you, Warren, for helping us out while we are live. I think that's very, very clever. Like NASCAR, Marlboro Man, and the Aflac Duck, Jack Daniels sparks discussion. Jack Daniels sometimes embraces its role as inspiration for expression, even tilting the whole podcast episode around itself. Country music's greatest muse, Around the Barrel with Jack Daniels, country music's greatest muse. But these songs are not all complimentary. James Prynne used Jack Daniels to symbolize sin in the night Jack Daniels met John 3:16. What? Chase Rice associates Jack Daniels with the devil and Jack Daniels and Jesus. When Kesha sings in her song TikTok that she brushed her teeth with a bottle of Jack, we know her night will not involve drinking responsibly. Oh my God, this is so good. I fucking love this so much. Songs that associate Jack Daniels with sin, the devil, or irresponsible drinking diverge from Jack Daniels' corporate message. The solution to this divergence is not censorship through litigation. The solution is more speech. I like this amicus brief so much. I like that we've gotten from political speech, the Marlboro Man, to Kesha. Look, y'all. That's the real connect the dots artwork of this brief, is that we have gotten from political speech and NASCAR to Kesha. That is the beauty of this brief. It just is. The proper response to critical speech is more speech. Trademark holders possess the right to respond to criticism and commentary. After all, a free flow of ideas from heart of the First Amendment, after all, a free flow of ideas forms the heart of the First Amendment. Hustler Magazine versus Falwell. For example, in contrast to the unflattering critique of musicians, Jack Daniels promotes itself as a drink crafted by wholesome, authentic people. While discussing his legendary postcards from Lynchburg campaign, ad man Ted Simmons explained Jack Daniels' country is a magical, mythical place that beckons American men. I've actually been to Lynchburg, Tennessee. Around the Barrel with Jack Daniels. It's dry. Look, things you don't know when you go to Lynchburg. But it's drivable. To burnish the image of the distiller Jack Daniel, a copywriter was told to imagine an old Southern lawyer like Atticus Finch in To Kill a Mockingbird, while Lynchburg, Tennessee should have a Wizard of Oz Emerald City quality. Jack Daniel's appropriation of art and cultural symbols rebuts the negative associations created by other speakers. Jack Daniels is not alone in appropriating art to shape conversation around consumer products. The French artist Christopher Gint recycles old Nike shoes by modifying the shoes with natural materials. As Gint explained, I like to play with the opposition and use symbols, giving them a natural and ethical twist. As if to say that nature will always triumph over man and his consumption patterns. The next year, Nike took the artist's symbolic concept and released Overgrown, a Nike shoe centered around the overgrown planet theme. Using the same symbols, Nike's shoe counters Gint, suggesting that Nike is environmentally friendly. Both the artist and Nike appropriated the symbolism of natural materials and the Nike swoosh to create opposing messages about consumerism. Far from needing a monopoly on trademark-infused expression, the world's largest companies have ample opportunity to draw on cultural iconography and participate in the marketplace of ideas. There is no reason to limit free exchange of expression and protect those who already wield the largest megaphones. The sale of expression enjoys full First Amendment protection. The difference between a cowboy selling a mythical version of the West and a cowboy selling cigarettes is the difference between a non-commercial speech and commercial speech. Trademarks, like the American cowboy, can embody both non-commercial and commercial speech. So we're going to get a lesson on trademarks that we're not going to go all the way through. We distinguish between those two embodiments of the cowboy and how embodiment is used. And if you all want me to make this one available too, I will link this as well, and add that link into Friday's roundup. Y'all let me know, because we're not going to have time to go through the rest of all of it, but we will zoom. If you guys want this entire brief too, because it has so many references to things that I also want to read, let me know and I will link the brief as well in Friday's email. So I will add it there. The test for non-commercial speech: what is being sold? Dog collars and ice cream scoops are quintessential utilitarian goods. If, however, a political party puts their own expression on these objects, the objects are non-commercial speech, subject to the full protection of the First Amendment. Protected speech intertwined with commercial and non-commercial speech. Is that a Joe Biden ice cream scoop? Yeah, that's a Joe Biden ice cream scoop. This principle that there is a difference between selling speech and selling goods and services matches this court's guidance in Fox that whether or not the speech at issue does more than propose a commercial transaction. The test of identifying commercial speech. This is a great argument with regard to commercial speech. And what is actually being sold. Protecting the sale of speech, even when attached to goods, complies with the First Amendment precedent that protected speech inextricably intertwined with a commercial good as non-commercial speech. Indeed, placing expression on a utilitarian good may heighten the expression, such as with this fly swatter sold by the Democratic Party, referencing an incident at a political debate. Truth over flies. By adopting the distinction between commercial and non-commercial uses of trademark, this court also respects the distinction between parody and non-commercial speech. Parody does not always sell speech. Often it sells other goods and services. For example, Just Candy LLC, oh my God, the way we loved these as kids, uses parody to sell candy cigarettes because the expression serves as an advertisement to sell candy. This is commercial speech, though Just Candy may leverage other fair use defenses such as parody. This is a very fair point. Message trumps medium. For First Amendment purposes, the difference between a movie and a commercial is not the medium. The difference is the message. It's a very good argument. Similarly, the difference between non-commercial speech and commercial speech is the message, not the medium. Jack Daniels and their amicus suggestion otherwise contradicts both this court's precedent and how Americans express themselves. Jack Daniels proposes unconstitutional content-based regulation. And then they're getting into the form of the speech. Political and artistic expression have always been everywhere. Aside from being unconstitutional, the suggestion that commercial products are not useful for political and artistic expression is ahistorical. Ahistorical. My brain added a lot of extra letters to that. Shirt buttons supported George Washington's inauguration. Mugs commemorated Thomas Jefferson's inaugurations. Spoons supported William Henry Harrison's campaign. In early America, political expression appeared on a variety of consumer goods as politicians sought to instill a high level of political activism and engagement. They're not wrong. We sell mugs too at Law Nerd Shop. This practice continues to the modern day, as shown throughout this brief. Political parties sell all manner of utilitarian objects loaded with political expression. I love this so much. Like political expression, artistic expression takes advantage of the opportunity to heighten statements by placing art in different mediums. I'm actually very interested to see what the Supreme Court is going to do. Let's see. Similarly, the widely respected contemporary artist Tom Sachs, if I pronounce that wrong, I apologize to all of the art aficionados in the chat. I don't know. Could sell books of his art. Instead, he sells collections of his art printed on playing cards. Prohibiting all but the pre-approved speech that appears on playing cards, tote bags, cups, spoons, mugs, beverage coolers, fly swatters, ice cream scoops, dog collars, and the Supreme Court calendars to be is an unconstitutional content-based restriction that contradicts traditions as old as our country. There is no need or basis for adoption of this rule. And then they go back through testing the rule. This is just so great. Let's see. The likelihood of confusion test is unpredictable. The likelihood of confusion test, it is unpredictable. It depends. It's just like when you see people arguing, oh, but it's fair use. How a judge defines fair use is also unpredictable. Fair use is a defense. You can still get sued and spend a lot of money fighting a fair use argument to a judge who might not see it how you do. The likelihood of confusion test is the same way. It's going to highly depend on the judge. The likelihood of confusion test suppresses speech by providing no predictability regarding when constitutional rights begin and end, rendering it overbroad. For example, we conducted a survey at the art studio about Jack Daniel's whiskey. Simple poll: Jack Daniel's whiskey tastes like dog poop. Ugh. The nectar of the gods. And then they listed who voted. Content Ninja and Gustavo think that Jack Daniel's whiskey tastes like dog poop. Jack, are you drinking yours straight up or in a cocktail? Because Jack thinks it tastes like the nectar of the gods. Is this within somebody's Slack chat? What is happening? Our colleagues who expressed an opinion that Jack Daniel's tastes like anything but nectar of the gods are, of course, wrong. But this is America, and they may express their opinion. Under the likelihood of confusion test, however, it is unclear how far they could go to share that opinion. Could they print their opinion on a pamphlet? What if the opinion is printed on clothing? Could they use Jack Daniel's filigree to surround their opinion stated on a t-shirt? What if they print that expression on a t-shirt using Jack Daniel's stylized font? Could they print the expression on a black t-shirt using Jack Daniel's stylized font and a replica of a Jack Daniel's bottle? Does it depend on where you live? The test itself is also a mess, with different circuits weighing different factors. That's why they're taking it up at the Supreme Court differently. As bad as that may be, perhaps the bigger issue is that a small minority, 10 to 15% of consumers, dictate the limits of free speech. Footnote 20. 10 to 15% is generally accepted standard. 10% supports a finding of likelihood of confusion, and 17% is clear evidence. And those are on the cases. Further undermining Jack Daniel's proposal is that it bans speech when survey respondents failed to understand the intricacies of trademark law. This is not an area of law widely understood by the public. For example, when the Ohio State University registered a trademark for the word "the," it prompted numerous explanatory articles clarifying that Ohio State's trademark rights in "the" are limited. Yes, I am still the Emily D. Baker. Unfortunately, failure to understand limits of trademark and licensing rights has led directly to censorship. And then they talk about that. Let us continue. I want to get to their conclusion statement. The likelihood of confusion test burdens speakers by forcing them not only to endeavor to speak so clearly that not even 1 in 10 consumers thinks the message is approved by someone else, but they must also make sure there is no confusion about their message anywhere on the internet. Are you coming to bed? I can't. This is important. What? Someone is wrong on the internet. Oh my God. It makes such a good point. It makes such a good point. It makes such a good point. So then they're talking about the likelihood of confusion test. That VIP engaged in non-commercial speech. Conclusion. For the reasons stated herein, this court should affirm the decision of the lower courts and clarify that non-commercial use of trademarks are fully protected by the First Amendment. William D. Patterson of Swanson, Martin, and Bell, John F. Bellicaster of MSCHF Studio. Yeah, well done. We appreciate you. It's a easy to understand amicus. It is very interesting arguments with great examples. Who doesn't like a Supreme Court brief with pictures and an art project in it? Not to mention, it's not just ridiculous. It makes the point well, the same way that The Onion did. It makes the point well. It makes the point well. It's, hey, MSCHF, we salute you. Thank you for fighting for free speech. It makes the point well. So, snaps to MSCHF. We appreciate you. I'm going to get to some questions. It's a really well done brief. I will include a link to the brief so that you can grab it. If you want to grab it, Supreme Court briefs are public. You can grab them off of the internet. I will just send it out in the link so it's easy to grab and so that you know that you're grabbing it from somewhere that you're not going to get computer viruses or what have you. But if you're worried about that, we also had a NordVPN spot on the podcast this week. You can go grab a discount code there, but I will send it in the email so you don't have to go find it. But well done. It's a well done brief. I'm going to pull the other amicus briefs and cover this a little bit more. Parity and free speech are one of the areas of Supreme Court expression, that in Section 230 that I'm most interested in. I don't cover everything the Supreme Court does, and I won't. But when we're talking about pop culture and culture, art, expression, speech are such an interesting part of culture and how it's being protected, what it even means. And since we engage on the internet and I talk so much about not just culture, broader culture, Bravo culture, but also internet culture, culture here on YouTube, what is and is not copyright, what is and is not protected, and at what point are you going to even be able to write a song or to have a conversation without it being, you know, stepping on somebody else or not? I don't know. But I think they're important and big conversations to have. And one of the most important conversations to have is about speech. And I think that that's a very important thing. So with all of that, I appreciate it. Ashley Marshall, I've learned 100%. I've learned more in this live stream than I have in 3 months. I've been in a digital marketing e-commerce program. Well, get the link when I send it and just grab all the books that they talk about in the history of these brands. It was a fantastically done amicus. I have nothing but tremendous regard for it. I love the cleverness. Look, I'm just a commentator. I like what I do a lot, but being able to break down how others look at culture and bring that conversation to light is something that is so interesting to me that that is just not my realm. And so I'm so fascinated by it. I love the conversation even around, an ATM where people put in their ATM card and it's a commentary on wealth and status and flaunting wealth. Such interesting conversations that I love, not just getting to shine a light on, but having a conversation about and looking at the thinkers around us that are really questioning, how do we still poke fun at society? And in a time where comedy, I think, has been mostly canceled for the things that comedians say, watching artists rise to say, no, we're still going to poke at culture. We're still going to poke at wealth and consumerism and ethics and corporations. I think it's fair. Parody is a poke, and that's a really interesting part of speech. And again, consumers will choose what they want to engage with or not, but we need to protect it so consumers can make the choice. My thought. Just the way I protect this community. I protect this community so that people can make a choice to either be a part of it or not. And I protect this space because those are my boundaries. But that doesn't stop people from not liking it. Emily, did you take any art history? No. None. No art history. Nope. I took philosophy classes. I took a lot of political science and statistics classes, a lot of law and society classes. But no art history. Nope. I took sign language as my language in college. No art history. So with that, we're going to get to some questions, and then I am going to have to scoot. We've got a lot of super chats. I want to try to get to those and our questions. So with all of it, thank you for being here and thank you for being law nerds. Let's get to some questions. I really love seeing how other people think. And I think that's one of the things I love the most about this particular amicus brief is you get to see the thought process of MSCHF and how they're breaking down the thought process behind trademark protection. I love it so much. It's why I love long form content and conversations and kind of the rise of who are our modern day thinkers. What are they thinking about? What problems are they trying to tackle? And how are those problems getting tackled as we go forward? So let's see. Question. Emily, is it odd to file a TRO against someone but not file charges? No. If Raquel has physical injuries, why not file charges? We talked about that a little bit earlier with regard to it being in New York. So no, it's not. Lauren said Sheena didn't punch Raquel. I think the RO is ridiculous. Fair. I wasn't there, so I don't know. Octo sent the connect the dots to everyone. We will send more connect the dots once the website is back up. Don't forget to go to Law Nerd Alert. The way I'm going to have to get on a call. I know Octo did, but I'm also going to need to get on a call with our host and see if they cannot, if every time we get a little bit of traffic, our site crashes, we're going to just have to find new hosting. Rosalind said, thank you for you and the Law Tubers for inspiration. Started my channel with Paw Nerd videos. Yay. One got sent to Chewy and they hired her. That's incredible. If you need a silly dog fix video, check it out. Thank you, Rosalind Duke. I love that so much. Paw Nerds are such great fun. Tracy said, I haven't watched VPR since right after Stassi and Jax broke up because he and Kristen hooked up and she had a meltdown. I was actually 48 at the time. It sounds like this is just continuing to cycle. Can you talk about Tiger Woods and his ex? Maybe. It's on the list. I know Rob over at Lawn Lumber is talking about it. Lauren Ellie said, EDB, look, I don't know y'all. I just work here. Me. Gone with the Gale. Ironic is the quote story this season is Raquel breaking off her engagement with James because the relationship was built on lies because he slept with Lala. So James slept with Lala and Raquel is sleeping with Scandival. Interesting. Okay, well, I'm gonna have to binge watch to catch up. Stephanie said, from what I've been told, and according to Professor Google, you can't get a TRO in Texas without filing a lawsuit first. I don't know Texas law. I would need to consult like Tom the lawyer. I imagine that there are exceptions for that. This is supposition. I'm sure there are Texas attorneys who can clarify better than me, but I imagine that there are exceptions for physical harm and things like that you don't have to file a lawsuit. For harassment, it might be the case, but for physical assault, I wonder if it is. I'm surprised how many people are asking if she's faking. Do you think that's because of what Amber Heard did with her restraining order? I don't know. I don't have enough background in Vanderpump Rules to know the personalities. And again, she has a cut in her eyebrow, so I don't think that that's faked. But again, I don't have all of the info on that. So Steph says you cannot sue when you are in Bravo contract. If you file, you'll be fired and never brought back, e.g. Nene Leaks. I remember Nene's lawsuit. That's very good to know. I would love to see those Bravo contracts. Probably never will get to. I've sent the funniest meme to you on Facebook Messenger. Lisa, I barely check Facebook Messenger. As always, the best way to get in touch with me reliably is through my publicly available email address. Vanderpump Rules launch with Sheena apologizing to Brandy for being the mistress. So why is Sheena punching people? This is a very good point. I remember that from the spillover with Real Housewives of Beverly Hills at a party at LVP's house. Ale, I don't know what to process this. Ask what should have done. She said, I should have asked if he wanted to be stabbed with the pencil. Look, kindergarten rules. This is where we start to learn these things. Lisa said, Emily, I got my people kimono today. I love it. They are great. I love them too. Give me 1 second. I do have a hard stop in 15 minutes. Thank you, Miguelina. How dumb does Jack Daniels think their customers are? LOL. We can all see it's a joke and a damn dog toy. Nefertiti, I agree with you. They don't. We'll see what the Supreme Court does. Poop, really, for SCOTUS? They couldn't use a better word? No, they had to use poop. They had to use poop. Banana Fana said, I bought a bunch of this kind of dog and cat toys at Christmas because of the case. I love that. There are a bunch of them. There are Chewy Vutons, and there are lots of riffs in the animal toy parody product world. Stacy said there is a huge picture of a dog on a chew toy label. Who is confused by this? I agree. Also a Heineken toy, and I love it. Rosie said, I made a logo for my husband, who is a 2X world champion equestrian vaulter. That's badass. And he told me it just looks like a giant male part. Oh dear. But we love it. I love it. Susan said, you must take time to binge Vanderpump Rules. It became my first favorite Bravo show, and I'm too old for their 19 to 49 age target. I'm probably too old too, but I'm here for it. Would love to use my secondary $25 bank account. That would be funny. I think that's what some people did. MSCHF doesn't want to be managed. No, they don't. As we are wrapping up and answering questions, I don't know if I will get to all of the super chats. So just know, we have not named the pickle yet. We're going to work on that tomorrow. For all of you, I am going to be doing a live stream tomorrow. I'm going to put up in our member spaces what we're going to cover tomorrow. We're going to cover when I cover 2 topics, I never end on time, and I do have a call, so I have a hard stop in a few minutes. But tomorrow we are going to do kind of a zoom of cases that we haven't covered in a while, so that we can start getting caught back up on all the things that you're like, but what happened to this and what happened to that? Does the lawyer for the amicus get to present oral argument too? I don't know if they will be at oral argument. We'll see. Were these sent to the justices? Yes, this is the brief that was sent to all the justices. They don't want their whiskey associated with poo. Very fair point. EDB, you could offer a service to website owners to check their ability to handle surge traffic. The law nerds make it happen. You don't see PepsiCo pitching a fit over the Mountain Drool dog toy that VIP also makes. Somebody's going to do it, and Jack Daniels decided they wanted to do it. The thoughts behind that, I'm very curious. And can we get a link to this? Yes, we can. I'm going to send that out. There's a lawsuit regarding whiskey fungus emanating from the Jack Daniels plant. Huh. I didn't know there was a whiskey fungus. That I'll have to look at. When Emily said I'm loving it, I automatically replied out loud with ba-da-ba-ba-ba. Fitting in a live stream about iconic trademarks. Thank you, Lindsay. Yes. Currently in grad school for marketing, and Coke completely invented how we see Santa today. He used to wear green, but we'd never put him in anything other than red now, and that is because of Coca-Cola. They reinvented him. Coca-Cola coming for Santa. Are there onion updates? I haven't taken a look at that case, but I will. Thank you all for what you're learning. Emily, idea for merch t-shirt with Poot in red boots. Oh, I'm definitely not putting Poot on a shirt. Where do we upload our finished Connect the Dots pages? I'm going to put a place on our community tab, and I'll put a place up in our Patreon as well, so that we have a place where we can share them. I'm pretty sure you can share pictures on, the community tab comments. You can also email me, and we can find a way to display them as lawnards. Surprising they didn't bring up Taylor Swift. Yes. Question. Do you think it would have been a First Amendment issue if Jack Daniels had demanded royalties instead? I mean, I don't know. I don't know if they would have argued the same way. Like, we don't need to, it could be, because they could say we don't need to pay royalties, it's parody. Text in here, you can get a protective order without a lawsuit. I imagine it would be very fact specific, right? It depends on, because some types of protective orders and restraining orders rely on harassment and other things. Injunctions are different than protective orders. So like a preliminary injunction normally goes along with a lawsuit versus a temporary restraining order that goes along with something like this. So that's why I said it depends. So I appreciate that. That's Sarah. Reason 1001 why I love ADB. Watch first hour of the stream while getting ready for a Zoom job interview. Logged off to do the interview. Came back and the live stream is still going. We're almost done. We're almost done. I have a friend who got a permanent RO on a person on YouTube. It was quite the experience to witness, I imagine. And this is the thing when we talk about restraining orders. At what point is online harassment going to be something that can be restrained? How does online harassment, targeted harassment, cyber harassment all play into speech like we're seeing here? These are large questions that we have to tackle, and I don't think any one of us can tackle them alone. I think as a group, we need to keep talking about them. And it's part of the reason I talk with cases like this, is how are we parsing through these problems? And how are we parsing through conversations around harassment, around speech? Where does speech become harassment, targeted harassment, internet harassment, all of it? It is funny. Poots and red boots. Poots in red boots. Mattel sued Aqua for the Barbie Girl song and lost. I bet I don't think their trademark extended that way. It's been a long time since I've looked at it. Space Log Geek, missed you this week. I've been here. Just drove down from the mountains. Looking forward to catching up. Yes, it's hard when you don't have cell reception. Don't worry. TikTok psychic updates coming soon. You are not allowed within an internet or me. You cannot come in with an internet of me. Like the TikTok psychic. Yeah. At what point? Like, there is some speech that is not free. And defamatory speech is the limits of that. So shutting it down, though, the hard thing with defamation is how much damage gets done before it can be shut down and how long it takes. Years and years and years. I want to know who is up for Claw Nerd. I like Claw Nerds. Claw Nerds, Paw Nerds, Law Nerds, all of y'all. You guys are the best. I will be back tomorrow for an extra stream this week. I will be posting, keep an eye for me in the member spaces as I talked about. I will be posting there. I have got to go get on a call. Thank you all for breaking my website again. I appreciate you. lawnerdalert.com. We will get that figured out. So with all of that, thank you so much. I appreciate you. And I will see you tomorrow for an extra special live stream talking about all of the cases that we've been covering, because we just haven't had enough time to get caught back up after Murdaugh. So with that, if you are a member and you missed last night's members only live stream, we do talk about Poot a bit. That is up in your member spaces, and will be up in your Patreon spaces right after this stream. I'm going to go push publish on that now. So I will see you soon. You can also, members, go find the Ringo case, which is a trademark case with Ringo Starr and the Ringo. That is available for you too, and I will see you in the next one. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.